motion writing at this point, Your Honor. This court is very well adept at applying the law in these matters. I think we should see what comes out before any sort of motions are written, and we can address any constitutional issues that I bring up at that time, so that we're not wasting the court's time and we actually have a record that could be purposeful, or if anything later on in circuit court, we can deal with it in any potential motions later, Your Honor. So I don't see a purpose for any sort of adjournment at this time.
But you believe that there's, or the stop was unconstitutional?
I do, Your Honor. At least that's what arguments we'll be making.
Your Honor, may I be heard?
You may.
Constitutionality and the legal basis for a stop is a legal issue that Your Honor is more than adept at handling. I agree on that. That's why I want to brief this issue in advance rather than have a messy, long, drawn-out preliminary exam where testimony would be taken. What I would be intending to submit is a motion and brief in support of what I believe is the legal constitutional basis. I am in no way suggesting that we shouldn't hold a preliminary exam still. In fact, I think we need testimony on this. I just request that I be able to submit a motion and brief in support of what I believe is a constitutional basis for the stop beforehand. To comply with the rule, I need 7 days to do that. I was just made aware of these issues by Mr. Milks late yesterday, starting at 2:15 p.m. I need 7 days to do that, which would be today. That's why I'm requesting the adjournment. I only need one.
If the court believes that we should brief the issue after we bring things up, I think it's appropriate then. I may find out information that makes it so that I don't have a constitutional issue. Could happen. And again, that's the purpose of the prelim, which the court knows. I think the opposing counsel knows. So I just like this opportunity, Your Honor. I'm not this opportunity. I just like to leave it on for the prelim.
I agree that we should still hold the preliminary examination. It doesn't preclude you from being able to argue the constitutional issues and or me holding a ruling while you brief the issue after proofs have been placed on the record. I think to his credit, if proofs are put on the record, that might resolve or explain what he believes to be a constitutional issue. I don't know what it is. That's what the purpose of these evidentiary hearings are for. So if he still has these questions and concerns in protection of his client, he'll make those arguments at the conclusion of the proofs, and then you'll have more than sufficient time after that to file your briefs, okay?
Yes, Your Honor.
Any other matters that we should address today?
Your Honor.
No, thank you.
Okay, so preliminary examination scheduled for the 18th of October, 9 o'clock in the morning. We will see you in person at that date and time, Mr. Layton. Do you have any questions at this time?
No, ma'am. Thank you.
Matters for the record.
There you go.
No, thank you, ma'am.
Thank you. Mr. Milks.
Mr. Honor.
Oh, one second. Did we find out?
The person I spoke with.
if there's someone here who hasn't started their video, who's on the Kusia device, please start your video. Okay, I'm gonna remove them because they, whoever it is won't respond. Mr. Palmer's not even on my docket today. On the record in the matter of the people of the state of Michigan versus Brett Salzman, 24-02833, council appearance.
Good morning, Joel Martinez appearing on behalf of the people of the state of Michigan.
Good morning, Your Honor. Stephen Milks on behalf of Mr. Solzman, who is present with us via Zoom, or public comment, he's friendly and nice to you, I believe.
Thank you. Okay, today was the date that was scheduled for probable cause conference, and the matter is scheduled for preliminary examination on the 18th of October. Council, you say you had some information regarding Mr. Salzman's counsel.
Yes, Your Honor, thank you. It's my understanding that Mr. Etheridge represents the defendant in this case. I've been trying to get in touch with Mr. Etheridge. I've had some assistant public defenders help me in that effort. Jared Austin was able to reach Mr. Etheridge. Mr. Etheridge's response to Jared Austin was that Mr. Etheridge was under the impression that the matter was simply being left on for exam and that he did not need to be here today. It sounds like there's some confusion. In fact, if that's actually what is happening today or not. I was unaware that he had not had contact with his client. I'm under the impression when an attorney says he's leaving the matter on, that's in consultation with his client. So that's the first I've heard of that. I have now asked another assistant public defender to reach out to Mr. Etheridge and to have him appear this morning for this matter. So my understanding is he should be appearing, Judge. I just don't know how timely that appearance is going to be, but that's what I've got so far. Thank you.
Oh, okay, sounds good. Thank you for that update. Mr. Salzman, have you spoken to your attorney before?
No, Your Honor.
Okay, well, if he's gonna log in, then we'll wait for him to log in. I don't have the issue. The jail is the one who probably has the timing issue. This is all I got all day. Yes.
I'm sorry, Your Honor. Regarding an email that was sent, it's my understanding that there was some sort of lockdown incident that made him unable to do or conduct visits, Your Honor.
That's correct.
I don't know the extent of that, Your Honor.
We have an email in our file consistent with that. That was on October 9th, which is Wednesday. Today's Friday. So Thursday was also an option. In addition to that, Friday during PCC is an option because the court is so gracious with opening up private meeting rooms. So we can't leave anything on if we haven't even spoke to our client yet. I don't know about you, Mr. Meltzer, but would you let someone represent you on a felony that's never spoken to you? Probably not.
Probably not, but I might represent myself, I guess.
we've been to law school.
I know.
Who do they say represents themselves?
The fools, Your
Thank
Honor,
you.
yes.
Thank you. We don't do that. But nonetheless, he has the right to have a PCC within a time frame unless he waived it. I've not gotten any information that he's waived, that both parties have waived the PCC. He's not even met with his attorney. He probably couldn't identify who his attorney is. So we can't continue. You can only continue after you've met with your client. And that's a decision that you all made to continue, not because you want to use the exam morning as another PCC for me to have to try to track you down in one of the other 3 courtrooms all day. Because we know that's what's gonna happen. But nonetheless, it's not your case, so thank you for filling in.
Thank you, Your Honor. Appreciate it.
We'll wait, see if he appears. I know you have another matter. I don't know where your client is, but you did speak with him.
I did, Your Honor, yes, Mr. Funches.
You intend to continue? The exam.
Mr. Corner said Mr. Etheridge is not available.
I think she forwarded it to you. Your matter,
Yes, Your Honor, we are looking to leave it on here, sir.
we'll continue to examine. If you spoke to your client, you don't need to go on the record.
I understand, right? The Mayor Pro Tem Bench.
Okay, and then Delaney, who's representing Delaney?
My understanding, Ms. Schroeder just got appointed yesterday afternoon because originally Ms. Delaney denied counsel, so I still need to send the PCC email if you want to conduct. I don't know if Ms. Schroeder's.
She logged out. If someone can let her know that Delaney is present. I don't know if she's in the building. Oh, yeah, she originally said she was hiring. Hi, Ms. Schroeder, did you want to speak privately with Mr. Delaney?
Yes, Your Honor, I just got the notification that I was appointed about 10 minutes ago, so yes, I would.
We were told, yeah, we were advised.
Your
Let's
Honor,
see.
if I may.
Yes,
I know Ms. Schroeder probably wants to review discovery, which makes any decision, but there is an offer on this case. The
Okay.
offer is to plead guilty to attempt resisting and obstructing and OWI. We will dismiss the other 3 counts.
I have made note, but you are correct. I would want to have the chance attempt. And you said that, and the OWI?
Yes.
Okay. And then there was a felony would be dismissed.
Yeah, it'll be attempt RNO instead of the RNO. RNO is the only felony. It's count 1.
Okay. All right. Very good. I've got that noted here. And yes, I would like to speak with her. Thank you. She appears to be having some technical problems. I will follow up with her. We'll just leave this set as the prosecutor indicated. Thank you.
Did she log off?
I don't know exactly what happened. I think she's having some problems because she disappeared from the breakout room and she couldn't hear or see me. Or I couldn't see her.
Do you want us to give you her phone number?
Let me see if is it, and the number that the court has end in 9072?
No.
Oh, then yes, I think I do need that number. Thank you, Your Honor. I got it. Appreciate
Thank you.
Thank you.
Mr. Salzman will treat next week as a probable cause conference because we can't seem to get your attorney here today, okay? There's Mr. Laney.
Stop, Snoop.
Can you hear us, Mr. Laney?
Yes. Host has asked you to start your video. Okay. Zoom would like to access your camera. Allow. Okay, I think I got it working.
Can you hear us?
Yes, I can hear you now.
Okay. Your attorney seemed to believe that there were some technical issues. So I did provide her with the number that you gave me during your time of arraignment.
Yeah, I updated my phone number 2 days ago or so with the clerk and the public defender.
Okay, can you put it in the messenger app on Zoom? Do you see where you can send a message to the court? It's chat. It says chat.
Oh, okay. There you go.
Okay, so she did have an updated number. We didn't have the updated number. We'll make sure she's advised of that, okay?
Yes, Miss Simmons. Huh? Thank you.
Your attorney is logging back in now, ma'am.
Thank you.